Hi, and thank you for joining us for our video series, Digging Deep into the Clery Act and Title IX Intersections. Clery Center and Victim Rights Law Center are really excited to present you with a series of different topics, advisors, accommodations, and authority for reporting to help you unpack the new Title IX regulations and make decisions that are a good fit for your own institution. Joining me today is Amanda Walsh from the Victim Rights Law Center. Amanda, would you mind introducing yourself?
Hi, I'm Amanda Walsh. I'm a senior attorney at the Victim Rights Law Center, which is a law center based in Boston and Portland, Oregon, focused on serving the legal needs of rape and sexual assault survivors. In that role, I do a lot of working with colleges and universities, helping them draft their policies and procedures, as well as representing individuals who are going through the process, either as their advisor or, helping to prepare statements, etc. I have also been a Title IX coordinator and understand how difficult it is to navigate implementation of new federal rules, whether it be Clery or Title IX. So I certainly can understand what folks are going through this summer to try to get up to speed by the implementation date.
Thank you so much. And my name is Abigail Boyer. I'm the Associate Executive Director at Clery Center. In that role and during my time at Clery Center, I've focused on training and technical assistance, working with institutions around the Clery Act regulations in particular. And to echo Amanda, certainly, although it was 2013, the last time we had amendments to the Clery Act, we know that the implementation, even for those regulations, is ongoing for many institutions. So we as organizations wanted to really find an opportunity to partner together to look at some of those key intersections between Title IX and Clery and really help to inform around three key areas that we know are hot topics of discussion at institutions right now. And so Amanda's going to share a little bit about the lens through which we're entering this video series, and then we're going to focus today on our conversation around the advisors of choice role.
So this series is not intended to be a comprehensive overview of either Clery or the Title IX regulations. We're just looking to have more in-depth conversations around three intersectional areas. The folks will get the most out of this series if you have had at least a chance to review the Title IX regulations and have a grasp on what Clery says in order to, I think, understand we're not going to cover the basics of either. It's also worth pointing out that we have references to the preamble throughout this discussion, and we're using the unofficial version, and we've given the link. So if folks are looking to explore more of that content, we know that it's 2,000 pages long. That's where you can find those references will be in that link for the unofficial version. So today we're going to look at advisors and cross-examination. This is an important area of intersection because we know that Clery introduced the concept of advisor of choice with the BAWA amendments to the Clery Act. And we've seen how institutions have implemented that. With the Title IX regulations that were released in May, that landscape is changing. And we just want to focus on a few of the ways it's changing and what institutions can expect.
Yeah, so we're going to start out by sharing just a little bit of history around this role of advisor of choice and that introduction into the Clery Act. Our organization, Clery Center, was founded by Connie and Howard Clery, the parents of Jean Clery, after whom the law is named. And so we've been very involved in the various amendments to Clery. And the advisor of choice amendment, or the advisor of choice piece of the 2013 amendments, was a really key addition. Some of you may remember that in 1992, the amendments of the Clery Act introduced what was called the Campus Sexual Assault Victims Bill of Rights. So since 1992, there have been specific rights and options for victims of sexual assault in particular, one of them being that both the complainant and the respondent, or the language that Clery uses is the accuser and the accused, were afforded the same opportunity to have others present. The 2013 amendments expanded this right not only for victims of sexual assault, but also for victims of dating violence, domestic violence, and stalking, to include the the advisor of their choosing. So what it did was it presented an option for somebody to be in the space to provide guidance, support to complainants and respondents during disciplinary proceedings, which didn't just include hearings, but also related meetings, formal and informal, to really just make sure that both parties had that type of support within the space. These requirements extend not just for students, but also for employees. So student and employee complainants and respondents have this right available to them that was introduced by Clery. Now, one thing that was really important in the Clery Act regulations was, although a person could have an advisor of their choosing, which really meant anybody, that could be a family member, a friend, or an attorney, anyone that they chose to be that advisor, what institutions were permitted to do under Clery was set restrictions on the role of that individual as a part of the process. So what role would this advisor of choice play? Because they were designed to be that guidance, or that person who could provide guidance, or to be that support person for the complainant and the respondent. And so what we've seen since the implementation of this advisor of choice role for many institutions was the potted plant approach. Because those restrictions were possible under Clery, what many campuses decided to do was to say, we're going to have this role of advisor of choice that we're required to have, but we are going to set limitations in their ability to speak during these proceedings. So oftentimes they certainly would be attending meetings and proceedings, but they wouldn't be actively participating. They are permitted to speak to the person that they're advising directly. Sometimes some institutions would allow an individual or an advisor to ask procedural questions or ask to take a break, but generally they were prohibited in speaking with the opposing party and had limited interaction with others as a part of the process. What we see now is that the Title IX regulations pretty drastically change that role. So there's still that advisor of choice role and function, and institutions are still able to establish certain restrictions on that role, but in the implementation and with some of the new requirements, they will have an active participation in the proceeding in certain ways, which Amanda's going to talk about.
So just quickly, let's take a minute to see what the Title IX regs actually say about advisors. And the most helpful place to look at this is actually a comparison between the Clery Act that Abby just talked about and the new Title IX regulations. And so if you look at a comparison, a side by side of what Title IX and Clery say, this is the exact language from both, short of a few differences in some of the technical language. For example, Clery talks about institutional disciplinary proceeding, and Title IX uses the term grievance proceeding. Title IX also specifically notes that a party can choose an attorney as their advisor of choice, although that was inherently understood in Clery as, a part of a student or employee's choice. But more or less, at an initial look, the two actually have pretty identical language about an advisor of choice and the institution's ability to restrict that advisor's participation. So the restrictions that the advisor can participate throughout the grievance proceeding or the institutional disciplinary proceeding. But very quickly, the Title IX regulations say other things that do influence the role of the advisor. So a lot of attention has been given to the requirement of a live hearing for colleges and universities. And specifically at the live hearing, the decision maker must permit each party's advisor to ask the other party and any witnesses all relevant questions and follow-up questions, including those challenging credibility. So this is the first time that you see that the institution's ability to control the participation of the advisor is somewhat changed as it was under Clery. So while institutions do have discretion to choose that role, in this one way, which is cross-examination at the hearing, they must permit the advisor to participate. There's also other language that changes this role a little bit, and specifically how much the institution or what level of discretion the institution has. So in the preamble, it talks about in order to meet the obligation for cross-examination, and that's the institution's obligation to allow cross for the advisor, A recipient, which is the Title IX regulation, the way it refers to institutions, cannot forbid a party from conferring with their advisor, although they can adopt restrictions about length of the breaks or general decorum of the advisor. So again, this is another way that you see that discretion on the part of the institution to determine the role of the advisor is limited in the Title IX regs in a way that it hadn't previously been in Clery. There are also ways that the advisor of choice is limited by the party, the complainant or the respondent. And specifically, it says if a party does not have an advisor present at the live hearing, the institution must provide, without fee or charge to that party, an advisor of the recipient's choice, so of the school's choice, who may be, but is not required to be, an attorney to conduct cross. So what does that mean? In other words, the party can no longer choose to be their own advisor. And again, this is another limit on choice. We have certainly seen parties act as their own advisors over the, since the advent of advisor of choice. And this, for at least this one role, which is cross-examination at the hearing, a party can no longer serve as their own advisor. And if they appear at the hearing without an advisor, one will be assigned to them to conduct cross-examination of the witnesses or the other party. So what happens if a party doesn't appear, but their advisor appears? So the party's advisor can still conduct cross-examination of the other party or witnesses, even if the party themselves does not appear at the hearing. So this is probably new and strange, and a lot of the institutions that I've talked with since the Title IX regulations were released, this is news to them. And what does this actually look like in terms of an advisor appearing without a party? That's not something that we have been seeing, on campuses since advisor of choice has since Clery introduced advisor of choice. What happens if a party and their advisor don't appear at the hearing? In that case, the institution is still obligated to assign an advisor to conduct cross-examination. Again, I've talked to a lot of institutions over the past month, and people are really surprised by this. How are we expected to assign an advisor when the party themselves is not either participating in the process or elects not to appear at the hearing and doesn't even send their own advisor? To understand this section, it's important to also keep in mind that the Title IX regulations say that if a party or witness does not submit to cross-examination at the live hearing, the decision maker cannot rely on the statement of that party or witness in reaching a determination regarding responsibility. In other words, if a complainant were to appear at a hearing and provide credible information, and speak with the hearing officers and participated in a cooperative manner throughout the investigation, but was not cross-examined at the hearing, their statements could not be relied on in reaching a determination regarding responsibility. So therefore, there must be some cross-examination to use their statements to find a person responsible or not responsible. And so in order to, otherwise the work that they've done or the time that they've invested won't be rewarded with any sort of credibility assessment, or we can't find a person responsible. And the same goes the other way. If a respondent appears and a complainant does not, and their advisor does not, we would still have to cross-examine that respondent in order for their statements to be considered in a determination regarding responsibility. I think a lot of institutions and administrators are really concerned about how quickly they will need to identify advisors and get them ready to act in this role. And so there's a few things within the regs that should make administrators feel a little bit better, which is that there is no expectation that institutions assign attorneys to be advisors. So I think this feels like this will be a huge cost to institutions, and certainly they could elect to use legal counsel, outside attorneys, to be the assigned advisor, but that's not a requirement. The preamble also says This provision does not require that advisors be legal counsel or impose an expectation of skill, qualifications, or competence. So certainly advisors should be trained, and we can talk about that a little bit more in a minute. But this should make administrators feel a bit better, because the idea that you have to identify potential advisors on your campus, whether using faculty or staff or outside of campus, and then in some way assess their competence or skill in such a short turnaround time feels like a pretty big sea change. And so this should make folks feel a little bit better. Additionally, there's a lot of talk about conflict of interest in the regs, especially as it relates to Title IX coordinators, investigators, and decision makers. There's training requirements and the requirement that they serve impartially and without conflicts of interest or bias. This requirement of serving without conflict of interest or bias does not apply to advisors. So in that way, the role of the advisor is different than the role of the other people that the institution is using to, conduct the process. So Title IX coordinators, investigators, and decision makers have this obligation for training around conflict of interest and bias. Advisors do not. So moving to just a few other additional considerations. As I mentioned, advisors are exempt from the training requirement, but it is certainly a promising practice for institutions to train advisors that they are going to assign to act in this role. Otherwise, the risk is that they cause more harm than help to the process. So at a minimum, focusing on what is relevant, some questioning skills, understanding the Title IX regulations position on prior sexual history and when that's permitted. This will be required that they have at least a basic understanding of this to be able to formulate questions and pose them in a way that's not harmful to the other party.
And one thing to consider here too is the Clery Act requirement for annual training for officials involved in conducting the proceeding. Right now, what the Clery Act requires is annual training on issues related to dating violence, domestic violence, sexual assault, and stalking, and on an investigation and hearing process that protects the safety of victims and promotes accountability. So the Clery Act requires anyone involved in facilitating that process or those procedures to participate in annual training. So that raises a bit of a question mark here as to whether or not, now that advisors are a part of that role and that function, advisors would fall into this bucket of individuals who can or must be trained. It's a question mark as to whether or not the regulations would look at that as a barrier, saying if you're an advisor, you have to participate in training. Could that be perceived as a barrier to the advisor or to the choice element of having an advisor of choice? But at the same time, we would raise that the Clery handbook, the handbook for campus safety and security reporting, as it lays out the different things that training must include, one of the required elements or one of the things that the Department of Education says that training should address is proper techniques for questioning witnesses. So now you have this advisor of choice role questioning witnesses without a very clear, bright line as to whether or not they would need to actually be effectively prepared in order to do that. So to echo Amanda, 100%, we would agree that if you have advisors that you are assigning because of some of what we just talked about, we really would encourage you to include them in that group of people that you are training annually to best prepare them for the way that they're going to be involved in the process. And we'd encourage you to think about, is there training that we could make available at a minimum to other advisors that are a part of the process, whether that's virtual training or in-person training. Again, a question mark here is that because Clery requires a prompt, fair, and impartial process that must be conducted by officials who do not have a conflict of interest or bias for or against a party, and considering this area of requiring annual training for officials, I think we'll be looking for additional clarity from the Department of Ed, the Clery lane, as to whether or not they would deem advisors of choice to now then be officials as a part of the process. So there isn't a clear, bright line there, but an important consideration as you're looking at what training do you make available or could you make available for individuals involved in this process.
Yeah. Thinking about the annual training that your institution provides, generally speaking, I think the Clery Act requirement gives folks an opportunity to assess that every time your institution changes its procedures, especially in a way that is as dramatic as it will is likely to be to comply with the Title IX regs, it's critical that you reevaluate whether the training you've been using is effective or continues to be effective. For example, this new role of decision maker might look very different than it used to. The concept of a live hearing may be new to your institution. Certainly the concept of cross-examination for many institutions in many states is not something that's been happening. As a result, decision makers or hearing board panelists will have to be trained on areas that they may not have been, areas that have been largely left to investigators during the investigation phase, whether it be assessing credibility, weighting evidence, again, understanding relevance, understanding prior sexual history. Many hearing boards over the past few years have been largely deliberative. They weren't fact-finding, didn't serve that function. Those folks didn't necessarily need to have questioning skills because they were often relying on the facts as found in the report. This will look really different, and therefore that training for those folks needs to look really different. There's one other point that I think from a trauma-informed lens, we would be remiss not to make, which is that cross-examination, we know, could be really harmful to folks involved. There's a lot of focus on the ways it could be harmful to a survivor. It could truly be harmful to a lot of both the parties and the witnesses involved in this process. Because of that, we recommend allowing for direct examination by the party's own advisor for them, meaning that if I am a complainant, allowing my advisor to directly question me. The reason we recommend this is we know that cross-examination is harmful, especially for survivors of sexual assault, dating and domestic violence, and stalking. And so allowing a complainant or victim to have their narrative, to at least be able to share their story, that might be the only validating or empowering experience that comes from the investigation and hearing process. And so allowing them to have that story before the cross-examination at least gives them one time to be actually heard. The alternative is that the hearing board and the decision makers might be reviewing this information in the investigation report, and the complainant and respondent are immediately subjected to cross without actually being able to share their narrative. And we just have concerns about how harmful this could be. A lot of people are asking, how can we implement these new Title IX regulations in a trauma-informed way? And in some ways, it's just hard to do. But I think this is one way that it could be a critical difference for a person. Many times complainants that I've worked with said the most validating part of the experience was at least being heard by respected members of my campus community. And without direct, that may not be an option for them.
So we want to thank you for joining us for the first of these 3 videos that Clery Center and Victim Rights Law Center will be sharing with you all. We hope that you got some new information and some new takeaways. Just a reminder that both Clery Center and Victim Rights Law Center do training and technical assistance with institutions. So as questions come up for you, we know that this is going to be a conversation that lasts over the next months and years. So as questions are coming up for you, as you're working through some of these issues on your own campus, we hope that you'll take away some of the information that we shared in this video, and that you'll reach out to both our organizations with any additional questions or concerns that we might be able to help you with. We're really paying attention to the needs of campuses and what they're asking for right now. So the more that we hear from you, the more that we are able to try to create the resources that can best support you as you are making the decisions that best support your campus. Thank you so much for your time today, and we look forward to hopefully seeing you again in the next 2 videos. Thank you.